Welcome to Real AI Now, a podcast about the real application of AI in business, brought to you by TwoImpulse. My name is Marc Giombetti and I'm product manager here at TwoImpulse, and I'm your host on today's show of Real AI Now. This episode is going to be about the legal world, legal implications of AI. And for this, I have a very special guest this morning, Vincent Wellens. Good morning.
Good morning, Marc. Thank you for having me.
Thank you. So Vincent is a partner with NautaDutilh and head of the Luxembourg Intellectual Property and Information and Communication Technology and Competition Practice Groups. And he's a true expert in the field on IT outsourcing projects about data protection with a focus on contracts and representation of in-jurisdictional and administrative proceedings, IP litigation, telecom and media regulation. And before joining NautaDutilh as a partner, he was also working as a technology lawyer for POST Luxembourg, the largest telco here in Luxembourg and a known operator in Europe. So thanks again for being here today, Vincent. And I would like to dig into the topic, AI and the legal profession. Can you say a couple of words about how you see AI currently impacting the legal profession?
Well, yeah, there is a lot to say around it now because, of course, with the rise of ChatGPT, it has an impact on all sectors, I would say, but it has a specific interest for the legal profession because you can also ask questions to ChatGPT on legal issues and you get a response. So I think it's not a bad tool in the sense that that some people who want to have a first advice already can get a grasp via ChatGPT. Mm-hmm. But of course, you run into these the stories that you hear nowadays that ChatGPT has also some hallucinations. That is, I think last week there was a case in New York that a lawyer relied on an advice of ChatGPT, and it appeared that ChatGPT had invented some case law. Mm-hmm. So that's of course
they couldn't find it then.
Yeah. So that's of course that's an issue. But more seriously, I think there are some very serious business models going on. You have heard maybe, Marc, about Harvey. Mm-hmm. That is an AI solution for legal services that seems to be implemented now at the major law firm Allen & Overy, which relies, amongst others, on the foundational model of ChatGPT, enriched with case law and also with the internal knowledge database at Allen & Overy. And apparently that tool is already assisting thousands of lawyers within Allen & Overy. Mm-hmm. So that's interesting to see that evolution.
Mm-hmm. So this is an interesting aspect. So basically there is the core model, right? And then these extensions being built, company-specific intention, which really make the difference in a particular area of expertise or the like. So looking at this, so let's say if I'm new in the legal profession, I'm a young legal practitioner, how will I get the right, let's say, exposure? How can these tools help me getting better in my day-to-day job? And isn't there the risk also that there is not the possibility to train a legal a junior getting the experience he or she would need?
That question is spot on, Marc, because I think in the predictions about the future of the legal profession, I think the junior lawyers will have it the hardest because of these tools, which certainly facilitate the job of a lawyer. Mm-hmm. You also must be able to see what does the tool do, and you must be able to be in a position to assess correctly the results that you get from the AI tool. And to do that, you need already some experience in the legal field. Mm-hmm. And you need also be trained on the functioning of AI tools themselves.
Yeah.
So that is really a big challenge. I think the older lawyers, which have already some white and gray hair, as I do, they they have to take the curve, obviously, to understand the underpinning of the AI tools. But I think we are in a position to see to make a distinction. Well, this result is probably not that correct, or we have to double check. And for the younger population, that will be really a challenge. And it's also a warm call to universities, etc., to enlarge certainly the scope of skills of young lawyers, not just to dry law, but really also application into these kind of tools. Absolutely.
Okay. So I want to pick up on one thing you mentioned in the very beginning. So it was a bit the making the law more accessible, or getting this first advice as an individual, right, before going to your lawyer or seeking legal advice. When building such, I would call it like a robot lawyer or legal assistant, what are the tasks you would consider which are most important that such a bot or a robot performs? And what are also the ethical considerations? So basically, where does it need to cut the boundary between I am competent in this and please seek for legal advice?
Well, I think there always should be the rider, please seek further legal advice, because that's you will see it in ChatGPT. That's also that's always a rider that is put under the advice. From the typical ethical considerations that we see, or bias, discrimination, I see a bit less of risk in the legal profession, for the simple reason that the screening of case law and also legal doctrine articles, it is already fairly anonymized, So, and if you see, if you take, for example, the case law that is published now in Luxembourg, before there was some published case law, and it was already fairly anonymized, but now it's even more. For example, if you're talking about a trademark, before you could see which trademark it was, and now you cannot even see which trademark it is. So I think it's not so handy for the legal practitioner, but it makes things more objective to unleash AI tools on case law. So what I mean by that is that already a fair bit of source of bias and discrimination is already taken away by the far-reaching anonymization and pseudonymization of case law and legal doctrines. And what a robot lawyer should do, it's the first level, the first level advice, obviously. But then, of course, a lawyer should look at it. It's a bit the same, like people are now very vocal about their health, and they're looking things up on the internet on what they could have. And I think
please seek a doctor.
People come better prepared to the doctor, I think, than they were 10, 20 years ago. And I think the same thing holds true for the lawyer profession, and it's a good thing.
So it's an opportunity to challenge your lawyer a bit with.
Exactly. And I think we, as a profession, we need that, because we have that epitome that we have actually, that we are in ivory tower still. We still have this strange dressing up. If we go to the court, it gives that flavor of that we are in the ivory tower. But I think it's a good thing that we are challenged, and it pushes us also a bit further in the reflection.
Okay, so it's an opportunity for becoming better, more reflection, and
but that means also that it will be, certainly amongst the lawyer community, it will be a survival of the fittest. That just having some high-level advice, or also some practices which are quite repetitive, just redrafting all the times the same documentation, I think that will disappear, and maybe rightly so.
Okay. Another thing which I read about and which is also interesting is like the other side of law, right? So not the lawyers, but really like the judges and how do you see jurisdictions around the world also preparing in terms of using AI in improving the way how they judge? Is that already a topic, or do you see it still at the beginning?
Yeah, it is certainly a topic, and you have some jurisdictions. Well, if we are here in Luxembourg, it's maybe not symptomatic, but I think it's a trend that is nearly everywhere. That there is a gigantic backlog in the handling of cases by the judges. They do not have sufficient means, so that means that there is a temptation, obviously, to let yourself help by predictive tools, etc. I think that's already ongoing. Now judges are trained, so they should, in principle, also be in a position to make a distinction between case A and B. What I'm afraid of, and what is a bit the beauty of the profession, that of course, with all these predictive tools, you will have a prediction, and you will also have a strong tendency in the case law that will be the result of the AI solution. And what I find the beauty is sometimes if you're going to watch in these, what we call minority case law, the cases where the courts decided in a different way, that case law will be maybe filtered out over time, and that would be a pity, because sometimes a case A is not a case B, and on basis of the concrete facts of the case, it may very well be that the minority case law is plausible, and that you can debate it, and that's maybe something that could be a backdrop. But most of the time, if you are pleading a case, obviously the majority case law is always the strongest element, obviously, in discussions with a judge, and the minority case law will normally not be followed anyway, so, but you never know. So
I see one thing which I personally find a bit scary is that when you look at jurisdictions where you have, for instance, also jury members, which, okay, the rulings are public, right? The preferences or the way a certain judge may judge cases, that AI is being used particularly to appeal and make your arguments in a way a judge would follow you. So, right, and I think that is also, I mean, I read about US, not sure about Europe, something which is happening already.
Yeah, that's an interesting case, because obviously even in Luxembourg, in front of which judge you have the best chances, and judges for the time being are not robots, are human beings, and I think that's certainly an element that you cannot underestimate in pleadings, etc. That there is still some small room for subjectiveness, and that would be an interesting. I think that would be a more advanced phase of AI, that you even could detect maybe some preferences of judge A and B, and that you could deep digger into that. But that again, that could also be maybe avoided, by just not naming the names of the judges, for example.
And then you have that,
But then you come, of course, then you have a bit of, because also with the rendering public of the cases now in Luxembourg, I think there is a bit too much information removed. And then you come actually in conflict with the principle that hearings should be public and decisions should be public as well. So that's an interesting thing to follow, but it's certainly a good point that Judge A is not Judge B, and there can be differences in how they interpret cases. That's for sure.
So this data is, I mean, speaking about data, but so these decisions are open or should be general public, right? Then obviously they should also be made available by the respective Ministry of Justice in a machine readable format, right? So that ideally you can also make use of them to, for instance, I don't know, train machine learning models or also search through these, etc. One thing, so want to move a bit into the topic of training data and how you can use data to train machine learning models, but also the aspects of data protection, right? We started off by saying, okay, there is some proprietary knowledge, for instance, Alan Overy used to train Harvey, right? But the core model is a GPT model. Can you say something about how do you want to make sure that when you train models, they are representative and also free from these biases, and what is important in your eyes?
That's a short question, but you could debate very long time on it. Yeah, that's the most representative cases now that you see popping up in the field of data protection are about that the results could be biased and could be discriminatory. Yeah, I think representative. I think there we have to follow the general rules of statistics, I would say. So I think the law would not be prescriptive. If the law says representative, it means representative, and then you have to look at the state of the art in terms of statistics. Free from bias, that's also a difficult question, because there have been cases, for example, in the Netherlands, there has been a case about it was a big scandal that the tax administration and the Social Security Administration had screened on fraud in family allowances. And that apparently, if you would be from Maghrebian origin or Eastern European origin, you would be you had a higher chance in the risk scoring when the algorithm calculates the risk scoring, then you would have a higher chance to be detected as a potential fraud case. And that was a big scandal. The tax administration also received a very big fine, or rather a millions fine for it in the Netherlands. And then you can ask yourself, where is the fault? You know, Mark, you are specialized in AI. It can lie in the data itself. The data is not incorrect, but also maybe the selection of the data. It can also be in the in who is actually setting up the parameters of the model.
Like the context, yeah, exactly.
The context, and it can be a bit of everything, or that even when you want to have the model right, that maybe the AI will look for some markers and will filter out some markers that in the end of the day appear to be biased and discriminatory. Now, in the tax administration case, it was really clear that the belonging to a certain nationality was integrated in the design. So that makes it quite obvious. But yeah, I think everybody is talking about the famous AI Act in the European Union, which will be enacted probably in a few months. But I think if you follow the principles and the rules that have been laid down on data governance stemming from the AI Act, then I think you are already a good way. And if you also document the choices that you have made in the design, in the selection of the data sets, it makes probably you also reflect on well, is this correct? Am I not going to be discriminatory? Whereas if you do not have these controls, probably the people who are designing it feel themselves a bit more free. And I think also having a diverse population amongst the designers could also help. Yeah, so because if you have Central Eastern European people in your designer team, most probably they would not be too happy to say, well, but it's an ethical debate, because of course we say bias and discrimination, but then that's also a legal question. What is bias and discrimination? Yeah. If, for example, a certain population is singled out as a higher scoring risk, yeah. but it's factually based. Yeah. What are you going to do? Yeah. Or that's now the thing about also gender bias. do you have to take positive actions in your design to fight the potential outcome that a genre would be biased? And that makes it very difficult, I would say.
I had a very interesting discussion with a former colleague from Singapore on different, so he's an expert on responsible AI and how to design these systems in a way that comply. And one of the starting points is also different value systems, right? So for instance, in the Asian world, you value elderly people more. In Europe, you would, let's say, if in case like looking at for instance, the trolley problem, right? Okay, is the trolley going to hit the grandma or the little child, right? So like in Asian culture, you would rather say, okay, it's the elderly who you pay a tribute to and respect. And in Europe, you would rather say, okay, well, the child needs to be, safe from harm. So also different value systems kind of like
exactly. And who is going to be the judge about that? Yeah, because sometimes you can have in a certain country, you have elections, there is democracy, and then that some country, you have the whole thing. Okay, it's maybe another topic, but you have in the States a topic about abortion. If the Republicans are in the power, then it's probably more mainstream, and if the Democrats are in power, it's not. You see what I mean? So it's a very difficult discussion, and it's also, and that makes it also very tricky.
Okay. I wanted to move to the topic of really liability of AI decisions or decisions being made by a machine. So how is liability determined when an AI model makes a decision that results in harm or a loss? How would that work?
Well, I think it's one of the underpinning principles that of the use of AI, that there always should be a human being who has a red button, right? Mm-hmm. And liability relies on that person who has the final decision.
But do you think in practical terms that's still feasible with this kind of like evolution of AI and sub-training, etc., that you get to a point where you cannot really say, okay, that was intended?
If it's not possible, it should be prohibited, because that means if the AI is going to follow its own logic, it's also one of the underpinning regulatory principles that will be made more clearly, and which already are enshrined in data protection law, is that you always must be able to explain the logic of the AI system. So if you're not able to do that anymore, you are infringement with that principle, and you cannot deploy the AI system. It's that's it.
I mean, I see that also as a bit a problem from how technology works, right? If you look, for instance, at neural networks, right? It's mathematically not feasible to tell by default what is let's say, the reasoning. Now, of course, there are, let's say, enhancements on explainability, right? Because regulators are asking for it, legal systems are asking, etc. But it's really kind of like this trade-off, right, between what can you do? And
exactly, but that's, I think that is the outer limits. From the moment that you cannot explain it and control it anymore, then it's over. I think then even when it could generate benefits for humankind, it's also I think there's a fair consensus. Well, at least 50% of the specialists in AI see it as a danger, that if it gets out of control, that it could be a danger for humankind. I think that's already a very large portion, I would say, that if the danger exists. And there have been cases already in the field of data protection law. For example, a bank not being able to explain why a certain person has a particular risk scoring. Then you are already in plain violation with GDPR and transparency principles. So, and then you get fined. So, and that's already the first case that come out, that this risk scoring practices in the banking sector. That's a big topic now. And if you cannot explain the logic behind the risk scoring and why I got a high score and if you cannot explain it, then
that's a problem. Yeah. And I think there also research has made quite good progress, right, in really, let's say, building enhancements of explainability so that let's say, AI can satisfy these criteria and explaining more what was the reasoning behind a certain decision taken.
Sure.
I wanted to pick up again on the liability and just pick your brain on one particular thing. So in 2016, the robot Sophia by Hanson Robotics, right? So like one of the humanoid robots was granted citizenship in Saudi Arabia. Do you think robots should have legal rights? And then if yes, why or why not?
Well, it comes down to the same question, right? That there should always be somebody who is in control of it. So I think that speaks against legal rights.
Yeah,
I would say so. Of course, you have the same discussion with children which are legally incapable, and there's always also somebody responsible for them. Animals, they also, of course, have some rights, but even there is discussion. But I think we should not grant rights to a robot, because that would, in my opinion, that would come very close to the discussion. Can we let the robot develop how it deems fit? And that's not possible because of this boundary that there should always be somebody a human being who can push the red button to stop it.
Yeah. I personally, when I look at this and calling it robot, right, I think there's always a bit, and I think it's maybe part due to science fiction, also the past, it's like this demonization of the robot, right? Like the humanoid robot, this robot which moves through physical space. But let's say the large majority of robots are like, the ones deployed on servers and running somewhere, and
exactly,
these are the ones which are running the show.
Yeah. If you would confer, if you have it very visually, if you are a Star Wars fan, like you have nice robots, and you would like to have to get them some legal rights, but you also have, of course, some bad robots. Or in the army of Darth Vader, for example.
Exactly. Yeah. So there's the good and the bad. Yeah.
Yeah.
You mentioned the AI Act being highly discussed in these days in Europe. Can you say a couple of words for our listeners and viewers? What is at the core of this AI Act, and also how does AI policy frameworks across the world differ, and what is particular about the AI Act in Europe?
Well, the AI Act is a very prescriptive text. Goes in quite a lot of detail. There are types of systems that are totally prohibited. So you have a kind of ranking.
Can you give an example? What is prohibited? What
is prohibited? Well, that's also a bit still under discussion. But what is certainly prohibited is that, for example, an AI system would influence you without you knowing it.
Okay. No.
It's a bit. That's a bit of an addition. Then you also have high risk AI systems, and you must know that it's not only about who is developing the AI system; it's also who is embedding it into a product, and also if you're using it. For example, if you have Harvey, Ellen Overy is using it. Yeah. So then all these actors are still considered to be stakeholders under the AI Act and have their responsibilities. So then you have high risk AI activities, and those are quite strictly regulated in terms of risk management, data governance. If it's embedded in a product, you also have You must make sure that it also has a kinds of CE marking. There is a crossover between the classical CE marking for products and AI being used for embedded in products. What is a novelty is that about the generative AI now and the foundational AI, for which nothing was foreseen in the initial draft of the AI Act. And of course, with ChatGPT, that enhanced the whole discussion. So there are also some transparency rules when you're using foundational AI and generative AI. So, for example, if you're embedding it in a high risk AI solution, you must follow some rules. What is very interesting, for example, if you take and I want to see whether that's will not be a blocking point. If you have generative AI, for example, ChatGPT, and it relies on copyright protected works.
Yes. Mm-hmm.
For example, ChatGPT, I think it crawls the whole internet, right? So
potentially also copyrighted content,
copyright protected or not. That you must be able to make a summary of the copyright protected works that have been used, and that will be very interesting discussion.
So the discussions I was having with a couple of also AI founders here in Europe is that they're very kind of like scared about these regulations, so that it's very difficult to run an AI company in Europe. There is a lot of limitations, and AI core development is progressing at a rapid pace. And the need to comply with all these laws is like making it harder and harder for the small ones, but actually feeding a bit big tech in a sense that they can afford let's say, the legal team of making sure that all the legislation is in place. Do you see that in the same way, or do you see it as
obviously the big tech has obviously more means to be compliant. If we look at it, if we have how would I say, if we have the experience that we had, for example, under GDPR, you had that same discussion. My big tech is probably best place to be compliant. Very often, even big tech has large problems to be compliant, and they really push the way forward to put their models there, so that it's nearly unavoidable that they are quite unstoppable. And then they try to adapt their models, and they lobby a bit, of course, because if you have an AI Act like this, it's obviously a highly lobbied piece of legislation. But what we see is that sometimes some principles are not respected, and then they wait until there will be an enforcement case, and then they will take it from there. Yeah. For example, if you see, okay, it's maybe on another note, but Facebook with international data transfers. It's only a few weeks ago that the data protection authorities have actually stopped the data transfer, whereas it was always clear that there was an international data transfer that would be very difficult to comply with the very strict EU data protection rules. So I think it will be a bit the same. So yes, they are more in a position to be compliant. They have the means, but I think some aspects will be difficult to comply with. That's for sure. And if it's too difficult, either they go along with their project and they take a few fines on the way, or they stop it. I think the founder of ChatGPT said it as well. So with the AI Act, we will try to comply with it, but if it's not possible, we stop it.
Yeah, so I think he was last week. Sam Altman was on a big lobbying tour across Europe, in Germany.
Exactly.
And, I watched that talk at my university, Technical University Munich. He was there.
I saw that
That was more in front of students, but also meeting the politicians in Berlin. I think there's a lot of, I mean, let's say uncertainty for tech companies also how the European market in particular develops, right? I think, okay, China is a bit the Wild West. The US is also much more liberal. I don't know. There's this saying, okay, the US is where technology is created. In China, it's copied, and in Europe, it's regulated. So I think
that's a bit about it. But we see, if we talk also with our, that's maybe true. But if you look at, for example, the same was said about the GDPR in the field of data protection, and then you saw that it became a standard across the world. So California has okay, there are differences, but California has adopted a quite generous privacy legislation. And I think in some major jurisdictions, the GDPR had that knock-on effect. And we see also, if you speak with North American lawyers, that there is also some principle-based regulation emerging in the US and Canada, for example, on AI. And their prediction is that what is going to be in the AI Act is a bit
like a blueprint.
Well, a blueprint, and it gets more flesh on the bone in terms of regulation. Because if you have principle-based regulation, it's principles, but how would that play out? You know, if you say transparency, explainability, and if you have then European legislation which lays down a bit in more detail, what is it? I think it will also have that knock-on effect in Northern America, for example, that they would say, yeah, but you have the EU AI Act, and it says that and that about transparency. Yeah.
So basically, like if you're a global company and you try to build your solution in a way you can, in essence, deploy it worldwide and use it instead of not running into additional problems.
I think the AI Act is definitely the most strict standard, that's for sure, and that will have an effect.
Okay, that's
if you want to deploy AI, of course, in European Union, but
okay. So what is, let's say, international and regulatory frameworks a bit? What shall we look at in the next 6 months up to 2 years? What are the things which you believe are really exciting and interesting as an AI person to look at? So the AI Act is one, is that?
Yeah, the AI Act is incontournable, I would say. You would also have, I think, in the framework of that AI Act, a lot of standards emerging, I think. I think there are some technical bodies who are working on technical standards. I think that will also be a very important point to follow, because in the end of the day, the AI Act is also a legal text. So even when it's a bit more concrete and the principle-based regulation in the US, it still is text and it must be interpreted by lawyers, technicians, etc. But I think there will be also some more standards, that's for sure, standardization in the field of AI. And then the interaction also with other acts like the GDPR, like also the Digital Services Act, which, for example, if you have a means on an online platform of referencing, there are also in these other legislations some items that deal with AI, maybe in a very specific focus, but you cannot forget about them, because the Digital Services Act also says that if you have, for example, a referencing scheme, I don't know, you're on Booking and you have or TripAdvisor, and there is an algorithm, obviously, who will decide also on the scoring or the referencing. You must also be able to explain it. So there will be a lot of overlapping, which makes it also interesting for a lawyer, because, for example, if a practice at the same time is a violation of the AI Act and the GDPR, will you culminate the fines, for example? So that will be an interesting discussion. But the GDPR will also, we believe the GDPR will still remain relevant also to enforce a big chunk of the use of AI, because the AI Act has not been adopted yet. Finally, so, and before it comes into force effectively, it will still take some time. And in the meanwhile, you will see that GDPR or competition law will also be used to enforce it.
Okay, that's interesting things to look at for the next couple of weeks and months, right?
Yeah, you saw it. I think the Italian Data Protection Authority had already some emergency measures issued by prohibiting ChatGPT in Italy. So
yeah, okay,
under circumstances, obviously, if ChatGPT would not use personal data.
Yeah. And I think there are also interesting, let's say, developments, right? So like also when using ChatGPT, can you, let's say it's in the default version, it's storing the queries, you send it to the prompts, right? And then making use of those to improve the models again. So that's probably something which will be addressed in the business and pro versions,
that was right? One of the biggest criticism, you know, the basis of lawfulness of data processing to train the model. Yeah. That I think ChatGPT had relied on legitimate interest, and that was not, for the Italian Data Protection Authority, that was not clear enough or not founded enough. Mm-hmm. Okay, so you run into these discussions, yeah.
Is there, let's say, thinking about summarizing and wrapping up a bit our discussion, so is there a very creative or unusual use of AI you have seen in the legal profession or beyond you were surprised about, like this wow effect or something which you found particularly shocking? Anything which comes to your mind?
Well, I have a bit difficulty with the fact that now with ChatGPT, everybody thinks AI is a total novel thing. It's already around for a while.
The 50s, yeah.
I think without knowing, we are already using it if we have databases, professional databases with case law and legal articles. There are already ranked in terms of interest, etc. So there is already algorithms working there, which goes already in the a bit in the direction of predictive justice without knowing it. I think it's a bit, everybody's now making a hype of it, but I think it already exists. And of course, if you think deeper about it, it is a wow effect if you take it from now until where we were 20 years ago, where we had to go in libraries to look up for things that if you would take that difference, you would make it a wow, but nobody says wow because it has been an evolution over years. Yeah. I would say for me, there is no solution that has created a wow effect now. I must say, for example, ChatGPT itself, that sometimes it comes, it gets nice solutions, and it's also very well behaved in redaction style.
Yeah, so it's a bit of a wake-up call also, right? I
guess. It writes very well, so it's also I think it's a wow wake-up call for lawyers to write more in a ChatGPT-like of way, which is a bit more colloquial, in a more understandable manner, and with respecting actually the an introduction, a nice summary. So that is the case. And then you have also applications like, maybe it's not so sexy, and we talked about it, Marc, before, like DeepL, you know? Yeah, you can say it's not wow because it's just a translation tool, but how it has revolutionized our work as lawyers, because we are working internationally. Written submissions before a court are in French. We have to have them translated in English. Before, you had to get a quote from a translation office. It costed thousands of euros, and now you just put it in DeepL. You have a very nice result, and you make a waiver to your clients by saying, look, this is an AI-generated translation, so it may not always be accurate, but clients are happy with it. If it's sufficient to have a wow effect, I don't know, but it's a massive progress.
I had this
maybe
discussion.
Not for translation firms, but for us, yes.
I had these discussions, I don't know, like a couple of years ago, where former manager wanted a search engine, nothing complicated, just as simple as Google. One box, one button. Okay, well, there's the beauty of simplicity, right? But what is behind is actually very valuable. And translation, I think, is one of these examples. It's just translation, but the power and, let's say, the thinking which went into this, let's say, approach is just a huge chunk of work. Vincent, I want to thank you very much for the interesting discussion we had this morning. So thanks again for joining me on the Real AI Now podcast. It was a pleasure.
A pleasure for me as well.
Yeah. And to our listeners, thank you for listening in, watching in. I'd like to ask you, if you like this episode, please give us a like and also subscribe to our channel. We are available on Spotify, Google Podcasts, and Apple Podcasts. And for now, everyone, thank you for listening and watching in, and goodbye.
Bye.